because we're going to go forward. So whether you can, we'd love for you to appear both video and audio, but we don't want to lose you on the audio. Okay.
I understand, Your Honor. Thank you.
Very good. With that, we are ready. Ms. Whiting-Bozich, we're ready for you.
Good morning, Your Honors. Alicia Whiting-Bozich on behalf of Harshad Mystery. If it may please the court, I would request 5 minutes for rebuttal.
Very good.
Appellant has identified 13 assignments of error in this case, a number of which are directed to the trial court's handling of this matter, particularly at the summary judgment phase, including granting summary judgment in favor of a non-party to a contract or loft with no admissible record evidence other than the contract itself. But really, that's only part of the story. Once you get through the numerous procedural errors, you are left with what at its core is a contract case in which the sellers are trying to sidestep their contractual obligations in order to capitalize on the rising real estate market. And they're doing that by asking this court to affirm an unreasonable interpretation of the contract rendered by the trial court. So how do I get to that assertion? On August 10th, 2014, the property that's the subject of this case was transferred to the Phyllis Minton as trustee for the Phyllis Minton Revocable Trust. According to the judicial admissions in the pleadings, right, and that's very important because the case law says that if you have an additional admission in the pleadings, you do not go behind those admissions and look at the record evidence. On November 29, 2018, my client, Harshad Mystery, entered into a contract with the sellers, both Phyllis Minton and the trust, to purchase the property. Another admission is that on that same day, both Phyllis Minton and her trust listed that property for sale. For the admission, the parties agreed. And by the parties, I'm referring to my client as well as both sellers, Mystery, as well as the trust and Minton. They agreed that the purchase price for the property was going to be $350,000, that the plaintiff would deposit $10,000 into the with the escrow agent, that plaintiff would remit, in other words, my client would remit $340,000 in cash on December 20th, 2018. That was going to be the date of closing. And on or before the date of closing, that the sellers, Minton and her trust, would transfer title to my client. And last, there is a provision of the contract, which is what we're disputing today, is that the purchase was contingent upon approval of co-owner. Now, given these judicially admitted facts, the only reasonable interpretation offered by any of the parties, and that's supported by the record, is our interpretation that we've proffered, which is that the contingency, we admit that the contract has a contingency. Our position is, and the reasonable interpretation is that since both of the sellers, both Minton and the trust, were part of the contract, and that the trust was the only party that could transfer title, that pursuant to the Florida Supreme Court case of Schreiner versus Fountain, that contingency was met at the time the parties executed the contract.
Well, isn't her name Phyllis Minton?
Yes, Your Honor.
Okay, her name's Phyllis Minton. On the face of this contract, it only says Phyllis Minton Trust. Doesn't say her individually at all. I know your client believes that, but on the face of this contract, it says Minton, comma, Phyllis Trust, seller. And then subsection 20 says co-owner.
Yes, Your Honor, I understand that.
And your client agreed to that. And your client is sophisticated in the real estate business.
Yes, Your Honor.
Okay.
Your Honor, I think you have to go back to the pleadings, right? If you look at the pleadings,
Are you telling me that I can't interpret the contract here on the appellate court?
Your Honor,
This is de novo. This is de novo. I can look at a contract just like you. So tell me, how is Phyllis Minton individually the seller and is the co-owner?
Because, Your Honor, pursuant to Corbelli versus Kinsey and Best Canvas Products and Supplies, and Corbelli versus Kinsey is a Florida Supreme Court case that stands for the proposition that when facts are admitted in the pleadings, that you cannot go behind those admitted facts and recast those pleadings. In other words, there is no evidentiary support required for that. So in this particular case, if you look at the pleadings, those facts that I just stated to you were admitted by the appellees, Minton and her trust, in this particular case. And so while I understand what you're saying, and I understand that you are able to read the contract and interpret it, at the same time, they admitted that they were the sellers, that they listed the property, they sold the property, and that.
But you're asking us to consider parole evidence.
Your Honor, I'm not asking you to consider parole evidence.
Well, then why can't I just look at it and figure it out?
I'm asking you to be. What I'm saying is that the law requires to be bound by the admissions in the pleadings. And
I understand that, but the depositions of the real estate agents who knew full well that David Orloff was the co-owner were admitted into evidence and not objected to.
Your Honor, I understand that. Well, first off, I'm going to disagree that the real estate agents knew and agreed that David Orloff was the co-owner. There is no.
Your client's agent said, "Let me know when the co-owner agrees."
Yes.
In an email.
Yes, and the testimony also from both of my clients and the real estate agent is that the co-owners to them were both Phyllis Minton and her trust.
Okay, but he didn't say, "Let me know when Phyllis agrees."
I understand. Well, I understand that, Your Honor, but when we're trying to interpret the word co-owner,
Yeah, we are.
the admissions in the pleadings, coupled with the fact that Phyllis Minton and the trust, like if you look at the contract as well, you're also going to see Phyllis Minton signed it and the trustee signed various portions of the contract. So if you go through it, you're going to see both names appearing on the contract in various places. And when I say that, I'm also referring to page 80, like 85 on the record. You'll see she signs as trustee. Another portion she signs Phyllis Minton. And so based on that, and based on my client who testified that they looked at the tax record, those two names appeared in connection with the property. So there was never an admission on my client's part that David Orloff was a co-owner. And quite frankly, if that's what they intended, they could have used David Orloff. The real estate agent indicated that he didn't understand what was going to happen in Missouri, and therefore that's why he did not identify Orloff specifically. Number two, the trial court found that, in fact, the trial court relied on the Missouri judgment. If you actually go back and look at the Missouri judgment, we don't dispute that there was a lis pendens that was filed in Pinellas County identifying a Missouri action. The issue with reliance on the Missouri judgment is twofold. Number one, if you actually look at the Missouri judgment, the trustee, who was the property owner at the time, was not part of that action. And number two, under Fall versus Easton, an out-of-state court, a Missouri court, does not have the authority to transfer an interest in the property. And in this particular case, the proposition that they're offering for interpretation of the contract is that, yes, we know that David Orloff was not a co-owner, but because he may or may not be a co-owner at some point in the future, that we were bound to that contingency, and we should have known that he may or may not at some point in the future become a co-owner. But if you follow Fall versus Easton, that logic fails. Number three, an alternative theory, the sellers never presented any evidence to the court that conclusively established that Mystery can never show that Orloff approved the agreement. So in our complaint, in the amended complaint, we offered an alternative theory that the contingency, if it's a contingency that was not a contingency to formation, that it was a contingency to performance, that contingency was made for the benefit of my client to the extent that there was going to be clouds on title. And therefore, the contingency was not satisfied by the appellees and the contract was breached, right? At the summary judgment hearing, there was no evidence presented by either appellees at either of the summary judgment hearings to conclusively establish that we would never be able to prove that alternative argument. And in fact, there was evidence in the record. That's the citation is 1957, that established that at some point prior to the initial closing, that Mr. Orloff had in fact approved the deal. And so because there was no record evidence of that alternative theory, and the court granted summary judgment in their favor without that, that the judgment should be reversed. And quickly, I just want to go through some procedural errors. You can reverse this case just based on the procedural errors, but obviously from our perspective, we'd rather the court address the substantive issues, but a number of procedural errors took place. You go back to the first summary judgment hearing with the non-contract party, Mr. Orloff, you'll see that right at the beginning of the hearing, it's in the record, counsel approaches the bench, tries to hand a packet of materials. Counsel for appellant objects to handing the evidence, sets forth the reasons for the objection, indicating that the material is not part of the record, and the court can't consider it. Then as you go through the hearing, the court sustains the objection. Despite sustaining the objection, the court then allows counsel to argue, testify, and look at the materials that were presented that she herself had indicated were not proper. And based on that, the court then grants summary judgment based on an unverified complaint and part of a record that wasn't even before the court on that particular day. And so at this point, I mean, if your honors don't have any questions, I will reserve my remaining time for rebuttal.
Very good. Ms. Howe? Ms. Dower, you hang on a second, because let me change the view on this.
I'm sorry. My name is Had Dow. If it please the court, my name is Had Dow, and I represent Phyllis Minton, the sole seller in this case. As the court has aptly recognized, this case is about the trial court's interpretation of a purchase and sale agreement of real property. This court's province is also reviewing the evidence on appeal and decides and comes to an interpretation on its own de novo. And as counsel has indicated, the existence of the contingency is not in dispute. The nature or the nature of the contingency as far as requiring a co-owner to agree to the terms and price is not disputed. They don't dispute the existence of the lispendants calling their attention to litigation between Ms. Minton and the co-owner, Mr. Orloff. So what they have left really is their own subjective belief of what it means as far as the co-owner is concerned and how the contingency should operate. And as the court recognized, the record is fully supportive of the existence of the negotiation and the nature of the exchange between the seller's agent and the buyer's agent. So when you look at the record where the buyer's agent replied to the seller's agent, let me know when the other party agrees, it tends to indicate the recognition of someone other than Phyllis Minton. And the co-ownership, according to the appellant, must exist on the day of the signing of the contract, and we disagree. And also, we do not contend or concede that there are more than one seller. We argued below that in order for the appellant to argue that there are two separate parties or that Phyllis Minton, the individual, is different than Phyllis Minton, the trustee, is an absurdity. And because we all know that a trust can only act through the trustee. Now, the buyer himself in this case, the appellant buyer, he doesn't deny the existence of the contingency or his signing of the agreement consenting to the requirement of approval by the co-owner. He testified that after he asked his agent to check on ownership of the property, the agent advised him Phyllis Minton and Phyllis Minton Revocable Trust. And he believed that Phyllis Minton was the only owner, and he was not concerned about the reference of a co-owner. However, approximately 2 weeks after signing the contract, he learned of the litigation between the seller and David Orloff. And he testified it was fine to him. He did not bother to even look at that litigation to see what it's all about. So now he appeals the trial court's grant of summary judgment, claiming that the contingency was either satisfied or waived. So in support of his position, I wanted to just rephrase or really repeat the issues as framed by him. Number one, the co-ownership did not exist legally on the date that he signed the contract. And number two, the contingency somehow apply only to the formation of the contract, but not the performance of the contract. So let us unpack those two contentions. First, we contend that the trial court did not have to confirm that an actual and legal partial interest held by David Orloff existed on the date of the signing of the contract. There are no provisions within the contract itself, no rules, no cases that require the trial court to confirm the interest held by David Orloff for the contingency to be valid, meaning the law doesn't require for a deed vested in his name as co-owner to be recorded in public records. Freedom of contract dictates that the parties can agree to any contingency they see fit for their situation. For example, the parties can make a contract contingent on the tenant's agreement to move out, for example. The tenant doesn't have to own the property. The tenant doesn't have to be the seller, but simply the contingency can say, we agree that the move out will be such and such date when the tenant is available to do so. Furthermore, for example, a financing contingency. The parties can make their contract contingent on the financing by some unnamed bank on undisclosed terms of a mortgage loan. They don't have to specify to the last details what the contingency should entail. So in this case, they have agreed for the involvement of a co-owner. Both sides recognize it. And secondly, a contingency by definition, I would submit to you, contemplates the performance of some act or the happening of some event after a contract is entered into. Appellant buyer is disagreeing with that, and they're saying that the contingency happens on the same day, simultaneous with the signing of the contract. So let's go back. By the definition of definition of what a contingency means, the partial ownership held by David Orloff did not have to exist on the date that they signed the contract. It could come into being after the seller and the buyer signed it, and it did come into being afterwards. I want to talk about the buyer's reliance on Schreiner versus Fountain. And I would submit to you that that case is not helpful to his position whatsoever. Schreiner involves two parties, the seller and the buyer. The seller refused to close because he would have to pay too much taxes, and so the buyer sued for damages. The proceeding in Schreiner is a motion to dismiss for failure to state a cause of action, or in other words, an attack on the sufficiency of the complaint brought by the buyer. And in particular, the criticism there is because his complaint or declaration failed to plead that the contract was approved by the owner of the property. On appeal, the Supreme Court read the phrase, and I quote, "This contract shall be binding upon both parties when approved by the owner of the property above described," and found that the circumstances surrounding the contract made clear that the owner and the seller are but the same person. Schreiner was decided on a limited record on a motion to dismiss. Our case was decided on a much more elaborate basis of summary judgment when there were more developed set of evidence available to the trial court. Schreiner actually stands for the age-old principle that in interpreting a contract, the court will not read absurdity into it. Rather, the court should arrive at an interpretation consistent with reason, probability, and the practical aspect of the transaction between the parties. And that's what happened here. If we were to apply the principle enunciated in Schreiner to our set of facts, it's not reasonable to read the contingency to mean that there were two sellers or two owners, and that they were Phyllis Minton, the individual, and the Minton trust. Again, as we know, the trust can only act through its trustee. Moreover, even if you were to entertain that argument, there's no evidence before the trial court or you that the co-owner, whether it was Phyllis Minton, the individual, or Phyllis Minton on behalf of the trust, ever provided approval for the price and terms of the contract. So even under this contorted analysis, the contingency was never met. The buyer has also claimed that the contingency was waived by him. And we know that the facts show the contingency was added for Phyllis Minton, the seller, for her own protection and her own benefit. So since she did not waive it, it was not the buyer's prerogative to waive that contingency that she inserted for her own protection. I want to go on and address the second contention made by the buyer, that the contingency for the quote and unquote formation of the contract as opposed to performance of the contract. Again, the buyer has shown you no legal backing, no case citation, no rules that distinguishes a contingency for formation of the contract from a contingency for performance of the contract. We all know that a contract is formed when the parties have meeting of the minds on all essentials of the contract. There's nothing left over for them to have a contingency. So if the buyer in this case and the seller came to an agreement on all essential terms on November 29, 2018, there would have been a contract. But there was a contingency that was not met, that was meant to happen in the future, and therefore the buyer agreed to signing off on it, and whether he believes who the co-owner is really is irrelevant. So this appeal, I asked you what is it really about? And I would point to the record, pages 763 and 764, to show you what it is all about. And I will read the testimony of the seller in this case. First of all, there's no co-seller, okay? Let's go back in time. Approximately 2014, Phyllis Minton was the owner of the property until January 17, 2019. The contract was signed November 29, 2018. As far as they referring to co-seller, I am assuming that they are referring to David Orloff. He became co-seller January 17, 2019. Someone screwed up. In fact, the Missouri court said that they should have put David Orloff as additional owner for this property before they put the property for selling. And someone screwed up again and did not do that. As far as I'm concerned, Orloff became co-seller only on January 17th. That is 49 days after the contract was signed. What does this highlight? I ask you. It highlights the buyer's own subjective belief despite actual notice of a co-owner. He chose not to investigate further, and upon learning about the litigation between the seller and the co-owner, he decided not to do anything. So he was not worried, and in his mind, his position was sound because the contract was signed before the co-ownership interest came into being. The buyer's subjective belief proves that the parties never had meeting of the minds. The buyer's subjective belief is also insufficient as counter evidence of a genuine issue of material fact to prevent summary judgment. The trial court here specifically found that the buyer was made aware of the existence of the co-owner by the act of signing the contract containing paragraph 20. And that is in the record on page 1356. This finding is factual and logical. If you read a document, you understand what it says, and you sign off on it, you have actual notice. Again, additionally, the parties do not dispute, and the buyer does not deny that the first notice of lis pendens was recorded in the public records of Pinellas County in June of 2018, several months before the contract was signed, giving him notice of the litigation between the seller and Mr. Orloff. So we come full circle to the fact that the buyer, who was informed that the seller's interest was limited by the litigation that she had with another party. Under those facts, Florida courts have held that the buyer cannot compel specific performance as an equitable relief.
Mr. Al, you'll need to wrap up if you're going to
Thank
reserve
you.
the
Yes.
balance for Mr. Widener.
Sure. So we submit that the buyer is not entitled to specific performance. There exists no material issue of fact or triable issues in this case. And I ask the court to uphold the trial court's grant of summary judgment.
Very good. Mr. Widener.
Good morning, Your Honors and Counsel. I'll try not to recover ground that anyone else has covered, but I want to focus on a couple of specific areas. Number one, specific to Orloff, when you examine the only 2 counts of the amended complaint, the court will note that it's specific performance that can't be held against Orloff. And number 2, breach of contract. Orloff wasn't part of the contract, so he can't be held under that. I would assert that the complaint itself is rather inartfully drafted, because while Orloff is mentioned in there, it's not specifically broken out the relief that plaintiff appellant seeks directly from Orloff. And so the court granting judgment just based on the pleading alone would be sufficient, because there's just no fact or circumstance under which the amended complaint as presented to the court would give the basis for plaintiff to have any relief against Orloff. So let's focus for a moment on the summary judgment evidence and the point that appellant counsel makes regarding the objection to my supplemental motion for summary judgment. When the court looks at the transcript of the hearing that day, the court will note that in fact counsel did object, and the court sustained the objection to the supplemental summary judgment. But if you look at page 9, I concede and recognize the objection and say, I'm going to rely on the summary judgment that was filed November 8th, 2019. I've got that here in my hands, and I would encourage the court to focus on that, because if you read that transcript in this section, what I say and what the court accepts, and it goes without objection, is, Judge, look at the summary judgment filed 11/8/2019. There's no objection, and in that to accepting that, and in that summary judgment, you see the Liz Pendens that's there, and I referenced that. You see the admissions, and again, I won't cover that ground because I think it's undisputed that there is an admission that the contingency was not met. Then there is the admission that comes in, because again, it's not admitted. And then finally, the 2 depositions in there. I say, paragraph 10, defendants have taken the depositions of Mystery and his realtor, both of which are filed and which defendant relies upon in support of summary judgment. And then I quote some sections that counsel just related to. But the bottom line is, so that was before the court at the time the court was considering summary judgment. There's another interesting little wrinkle on the Florida Rule Civil Procedure 1.510C. And while it explicitly asserts that, quote, evidence, and if you look at the rule, it's either in a parentheses or a quote, where it sets off what is evidence that must be designated 20 days in advance: depositions, admissions, affidavits, all that. But then if you go a little bit further down the rule, it says the court shall enter summary judgment if the pleadings, and then the quote, summary judgment evidence, show that there's no disputed issue material fact. So the pleadings come in, and what's the purpose of the summary judgment rule in designating evidence? It's so you're not taken by surprise by some affidavits or depositions that took years ago or whatever. But the pleadings, you're bound to, because those are your pleadings. And so in that exchange between the judge and she's asking, how wasn't it met? Well, they say so in their own complaint. Regarding the designation of co-owner, I think we would all agree that if the contingency had said, this is contingent on Orloff signing this, that we wouldn't be here. So they're trying to, take this little linguistic incongruity and somehow assert that they didn't know what co-owner meant. And down in that transcript a little bit more, Judge Williams asked plaintiff counsel, appellant counsel, so what do you mean Phyllis and Phyllis meant? And counsel says, I don't want to get into that, or I don't want to admit that or talk about that here in this hearing. So that is problematic. She just doesn't even want to address the issue that the court asked in considering summary judgment. The final point that I want to pay attention to is the issue of full faith and credit. It's difficult because there's not a lot of case law on that. The cases that we cite in our brief talk about these cases where parties that subjected themselves to the jurisdiction of the court subsequently want to take issue and claim that there wasn't jurisdiction over the res or the rim of the property. But in this particular case, you have 2 parties that, as I say in the brief, were at blood feud, mortal warfare with one another, Orloff and Menton. and they subjected themselves voluntarily to the jurisdiction of that court up there in Missouri, including the property, I would argue, but the two of them certainly were before the court. And they said to that court up there, we're going to trust you to decide what should happen with this. And the court issues orders that are undeniably due to be respected by this court and by Judge Williams. Because think about this, the judge up there has ordered these two parties to do something, Orloff and Minton. Minton finally gets around to doing what that judge up there has ordered her to do. And as I said in the trial court, the court can only respect the in personam jurisdiction of that court up there and what the court ordered them to do. And in fact, what these parties finally did. And to do anything other than to respect that would have this court directing Minton or Orloff to violate the otherwise lawful orders of that court. So the procedural issues that are before the court, I think we've addressed with there was no objection made to the summary judgment evidence that was articulated explicitly in the original motion for summary judgment. Counsel is absolutely correct. All those other affidavits that I subsequently identified, she timely and properly objected to, that didn't come in. The court didn't consider it. So now we're left with what the court is considering, and that is the complaint and the other information that's in front of the court. And I would finally just adopt the argument of Minton and her counsel, because as the court can clearly identify, there's one order granting summary judgment and there's one final judgment in favor of defendant. So we are joined at the hip in all of those defenses. And if the court finds a basis to affirm anything from Minton, then likewise that flows and affirms everything for Orloff at the same time. I thank the court for its time, and we'll reserve or respond if the court has questions.
Thank you, Mr. Wiener. Ms. Whiting-Bosich, you have your rebuttal time.
Thank you, Your Honor. So there were numerous arguments that you heard from the appellees that were never briefed, right? So first, you just heard a very long argument about the procedural appropriateness of the actions that the court took. Mr. Orloff never briefed that issue. Secondly, again, you heard argument about mutual mistake. That was not briefed by the appellees either. So what does this come down to? You keep hearing about, well, there was only one seller. There wasn't one seller. As part of the admitted pleadings, Minton and her trust were both the sellers. So that is just, there's no evidence for it. The record affirmatively establishes that there were co-sellers. The record establishes that there was one owner, which was the trust. The trust agreed to sell the property to my client. You keep hearing about you are bound by Missouri. The reality is that the two parties that were in Missouri are Minton in her individual capacity and Orloff in his individual capacity. The trust was never subject to that litigation. So even if this court is not bound by the Supreme Court under Easton, it doesn't matter anyway, because that judgment never had any effect on the property owner, which was the trust. As it relates to, they're talking about formation versus contingency to performance. The contingency reads, the purchase is subject to co-owner approval of price and terms. Price and terms goes to the very basic material aspect of the contract. If you don't have price and terms agreed upon, there is no contract. So Schreiner versus Fountain is on point and is applicable because the price and terms were determined by the sellers and my client. So this idea that my client is bound to a contract, that he has to pay a deposit, that he has to be ready to close, that he has to go out and buy title, get a title report. He has to do all those things. And go back to the appellee's pleadings. What they say is, my client was responsible to satisfy the contingency to close. In other words, my client was responsible to go out and find this purported co-owner and get an unidentified person to agree to the price and terms. And then if my client doesn't do that, then my client, is responsible and liable for attorney's fees, that he loses his deposit, and he breached the contract. That's the reality of the proposed interpretation that they're giving you. If you look at their pleadings, they talk about, excuse me, sorry. In various parts, she talks about my client's subjective belief. Step one is the contract ambiguous or not? If the contract is not ambiguous, you don't get into subjective belief. Once you get into subjective belief, then it becomes an issue for the trier of fact, and it's not appropriate for summary judgment on either side. So under those circumstances, spend all the time on subjective belief, but you don't even get there. If the court determines that the word co-owner is plain, given the fact that the two sellers agreed to the price and terms executed by my buyer is ready, my client was ready to perform, had provided the deposit, had been ready to close, then you don't get to subjective belief that he testified to after he had an opportunity to talk to his lawyers, which is where that testimony comes from. I won't belabor the points any further. My client, we have identified 13 different errors committed by the trial court relative to the summary judgment entered in favor of Orloff and Ms. Minton and the trust. Orloff failed to rebut 6 of the assignments of error that were committed by the trial court. And the fact that the court granted summary judgment to Mr. Orloff, even though he's not a party to the contract and without any evidence, record evidence other than the contract itself, the court can reverse on any one of those 6 reasons. But the reality is we would ask the court to reverse, remand, and direct the entry of judgment based on the substantive legal issues presented. Namely, that co-owner approval was given by the sellers, Minton and the trust, when they executed the contract, and there's no legal or factual support to the contrary based on their admissions in the pleadings. And we're asking the court to write an opinion that announces the most reasonable reading of the contract, which is that the co-owner approval was required as a contingency to the formation of the contract, and that contingency was satisfied when the parties executed the contract as set forth in Schreiner. And we're asking that you write an opinion, regardless of the outcome of this case, regardless of how the court ultimately decides substantive issues, because we believe that the trial court could use some guidance as it relates to the contingency question, particularly formation versus performance, because there are still outstanding issues at the trial level, including entitlement to attorney's fees.
Thank you, Ms. Whiting-Bosich and Ms. Dow, Mr. Widener. That concludes the presentation of that case. Don't forget to